This is a guilty plea. It's not an adjudication. Prosecutors and Cohen cut a deal. It's a plea bargain. It's not a precedent. It won't be cited for anything. Nobody cites plea bargains for precedent. They obviously had more on Michael Cohen, or Michael Cohen wouldn't have cut a deal. Cohen cut a deal. Now, a campaign expenditure must be solely for a campaign activity. It must come from a campaign activity, not an activity that occurred before the campaign. A candidate who spends his own money, or even corporate money, for an event that occurred not as a result of the campaign is not making a campaign expenditure. Now, let me give you some examples. Let's say a candidate had said, and was a big businessman, we owe vendors money. There's some dispute over this. Let's get them paid so it doesn't look bad for my campaign and so I look good. Or let's say he settles a lawsuit that was initiated before the campaign or outside the campaign, but he doesn't want it to be an issue during the campaign, and he says to his lawyer, let's go ahead and settle that. There's absolutely nothing illegal about it. Now, all you talk show hosts and lawyers who are listening to me, take notes. I want you to copy what I say. Let's say a candidate says, get a non-disclosure agreement, pay the funds out of my pocket because I don't want this person to attack me during the campaign for something that occurred before the campaign. That's perfectly legal. That's not a campaign expenditure. What the prosecution has done here, paid at the direction of the candidate to influence the election, is contorted the law. Can you imagine if the prosecutor's right and I'm wrong? How would we even work through these issues? So the fact that Michael Cohen cuts a deal, the fact that Michael Cohen's been recording his clients, the fact that Michael Cohen didn't pay his taxes for 5 or 6 years and lied on a loan application, and then agreed to 2 campaign finance violations, doesn't create precedent, legal precedent of any kind. There's been no judge. There's been no jury. I just want to be abundantly clear about it. Well, the president's in the crosshairs now. Now he's a target. President's been in the crosshairs. The president's been a target. Why do you think the prosecution wanted those 2 counts? Why do you think the prosecution wanted those 2 counts? So they can claim that this is what the law says through the plea bargain that was cut with Cohen. But just because they say it doesn't make it true. It's not precedent for anything. So let me go through an example again. I decide I'm going to run for Senate. And I have this employee or this individual who accuses me of X. I deny it, but I don't want it to be an issue. So I say to my lawyer, pay the guy. Pay him. Give him a non-disclosure agreement. 1,000 of them are done every hour of the day. Just shut the guy up. I want to run for office. Shut the guy up. Pay him something. And he does. Then I decide to run for Senate. Let's say I'm running for the Senate. I'll make it even a tougher case. I'm running for the Senate. And the guy says, I'm going to screw your candidacy. I'm going to raise all these issues. I say to my lawyer, let's get a non-disclosure agreement. I'll pay it out of my pocket, or if it's a corporation, I'll pay it from the corporate funds. We have non-disclosure agreements all the time. Let's shut the guy up. And we pay it. Neither are illegal. If I took money out of the campaign funds that I'm raising to pay somebody under a non-disclosure agreement, that's illegal. That's illegal. But that's not what I've done. That's not illegal. Paid at the direction of the candidate to influence the election. Now, there's a lot of things you do to influence an election as a candidate that are legal, that are perfectly legal. Maybe you decide to buy a certain type of property or a certain type of car or whatever, with your own funds to demonstrate you're a regular guy because you want the people's vote. You want to be a regular guy. So I sell my Maserati and I buy a Chevy Impala. See that? I'm doing that to influence the election because now I'm a regular guy. Is that a violation of the campaign finance laws? If I don't use campaign money, I use my own funds or corporate funds or what have you? No. Then the prosecution says, not only that, it's an illegal corporate contribution because corporate funds were used. Well, so what? It's my money. It's my car. Well, you want to influence the campaign. Well, there are a lot of things that influence a campaign that aren't a campaign violation. I hope this makes sense to you because you're getting a ton of propaganda. A ton of propaganda. That's not to say the prosecution won't try something nasty. But I'm telling you what the law is. And I'm going to bring on this program in a few minutes Bradley Smith, the former chairman of the Federal Election Commission, who himself lays out this case and has on this program and in the Wall Street Journal. We'll be right back.
Mark Levin.
I want to welcome Bradley Smith to the program, former chairman of the Federal Election Commission, law professor now. How are you, sir?
I'm good. How are you, Mark?
Good. I had to drag you out of your vacation. I apologize for that.
Well, for you, Mark, I'll do anything.
You're a good man.
For you.
Would you sign a non-disclosure agreement? But anyway, let me ask you a question. I'm watching some what I consider to be inaccurate and hysterical reporting. I'm also watching some professors who have not really acquainted themselves with FEC and campaign law. Let me ask you a few questions, Bradley Smith. If I'm a candidate for the Senate, and I tell my lawyer, look, I want you to pay Frank, who just keeps attacking me and smearing me and so forth, or Frank, who has negative information on me, I want you to get a non-disclosure agreement, an NDA, like corporations do, or people do 1,000 times an hour in this country, pay him, and I want it to go away. And I use my cash or corporate cash. I don't use campaign cash. And it has nothing to do with the campaign, actually. I've had this relationship with this guy. It hasn't gone very well in terms of employee-employer. And is that a campaign violation?
No, it should not be. Assuming that Frank is complaining about things that you've done in the past or threatening to expose things he thinks are bad behavior, that you cheat at golf or whatever it is, and those are things that are not related to you running a campaign, right? That's not a campaign expenditure, even though it might incidentally benefit your campaign. Even though part of the reason you decide to pay it off now is so that you won't have to deal with all the press inquiries and some people who believe these charges and so on. But it doesn't make it a campaign expenditure. An example would be, let's say Frank had actually sued you and you had a lawsuit pending, and you said, this lawsuit is totally bogus, but I don't want to worry about this during the campaign, so let's just settle it with Frank. Doesn't turn it into a campaign expenditure. It's still a personal expenditure.
So you want to clean up things that have taken place that, in your view, may bring negative press to your campaign, and it might influence the outcome of the election, and you say, you know what? These are private matters. This is my money. I have every right to spend this money to do that. Correct?
Right.
Now, what if the converse were true? It seems to me A complaint would be filed every single day against candidates who are running for office when they spend their own money or corporate money to look better, or to quiet people who are attacking them, or to do whatever, buy a different kind of car, wear different kinds of clothes, get, as you point out, get a new haircut and so forth. I mean, the list of charges would be endless.
Well, yes, potentially it would be. Let us take, for an example, suppose a candidate or a successful businessman and had a number of corporations, and he said to his corporations, let's give all our employees a big Christmas bonus this year because voters will see that I'm a really generous employer, and that will make them think highly of me. Right? Does that turn that into a campaign expense? Can they now use campaign funds to pay those bonuses to employees of the business, not of the campaign? Can they use campaign funds rather than the business funds? The answer is no. That's not a campaign expense. It's still an obligation of the business. It's an obligation that does not exist irrespective of the campaign.
But if I want to pay it out of my own pocket, it's perfectly fine.
And right. If you want to pay it out of your own pocket, too, it would be the same thing.
So what the argument seems to be, and it hasn't changed, is that if I spend money to make myself look better or to take away negative issues in my private life, my business life, my employment life, and use my own money, that somehow that is a campaign contribution. Correct?
Right.
Which it is not.
That's right. It is not.
Now, you're a law professor. I'm a lawyer. We've litigated and so forth. This is a guilty plea. It is a plea bargain, correct, with Cohen?
That's my understanding.
Does this have judicial precedence, stare decisis? Is it controlling in any way on any future case in that respect?
No, it's not the same as if you had a judgment from the court defining this as a campaign expenditure. It's a plea bargain, and people plea bargain for lots of reasons, and one of the big reasons is that they plea bargain down to a lesser charge, or they get a lesser penalty for pleading to something, and these prosecutors can come at them with all kinds of charges, and they just decide it's best not to fight it. So sometimes people plea bargain when they think they're totally innocent, but they don't think it's worth fighting. Sometimes they plea bargain to one charge just to get, because the penalty for that is less than the other thing they would be charged with. Lots of reasons why people plea bargain, but bottom line is, just as you said, it's not judicial precedent that you can cite in court to prove the law of the case.
So if a prosecutor sits down with a target and says, look, we got multiple counts of tax fraud here, tax evasion. We've got false statements on loan applications. Okay, we'll knock this down to 5 tax evasion charges, 1 false statement, and we want you to plead guilty to these campaign finance issues, which they believe are violations, or they claim are violations, unlawful corporate contributions, excessive personal contributions. Now, you sign on the dotted line, and he signs on the dotted line. Okay, that's him signing on the dotted line. That's not an adjudication. And by the way, just because the prosecutor says it's a violation of law, at least in my entire legal career and experience, that doesn't make it so. Correct?
That's correct.
All right. Well, Bradley Smith, I always appreciate your expertise. It's very, very important because this can get complicated, particularly with all the static going on out there. So enjoy your vacation.
Thank you very much, Mark. Good talking.
All right. You too. Be well.